Hello, welcome to our Ripple Tech Conversation series. Today, we're just going to jump right into things. We have Professor Jacob Victor, who's going to give us an overview of trademarks and copyright law. And then Professor Sabrina Safran is going to do the same with patent law. We really want to hear from you and your questions, and so please put them in the Q&A, and then we'll have 15 minutes starting at around 12:45-ish, and we'll jump into those. All right, Jacob.
Great, thanks so much, Ellen and Sabrina and Katie. So I'm going to just jump right into it. This is going to be a much more cursory discussion than you would get certainly in a class, mostly because I want to make sure to leave time for you to ask questions. So I'll start with copyright. So what is a copyright? Copyright is basically legal protection for any kind of original work of authorship fixed in a tangible medium of expression. That is the sort of legal definition. So original, it has to be an independent creation, demonstrate some small amount of creativity, however minor. It has to be sort of a creative work. It can't be functional, but that's a pretty big umbrella. Literary works, you can see from these photos, video games, works of fine art, photographs, and the like. And it has to be fixed in some kind of tangible medium, which basically means written down, expressed in some form in which it's reproducible. So what does a copyright actually give you? It gives you basically protection against unauthorized sort of use of your work in various ways. And that's generally understood to mean things like copying and selling, performance, and display. You get this protection the minute you make a new work. It doesn't actually matter. You don't have to register anything. You just get it when you write something down, record something, and the like. You can register it at the Copyright Office, which is a regulatory agency, but you don't need to. You need to in order to sue for infringement, but you can do that later on. That's in contrast to a patent, which Professor Safran will be talking about, where you really do need to register things. But once you have a copyright, once you've created something, you can protect it in a variety of ways. The less straightforward way of protecting it is you can prevent people from making what's called an unauthorized derivative work. And this is where we see a lot of interesting litigation. So, recently, the Ninth Circuit upheld a judgment against the creators of Blurred Lines, Robin Thicke, for infringing a Marvin Gaye song, for creating a new musical work that borrowed too much from that song. There was an interesting case involving an unauthorized Harry Potter lexicon, where the court held that was within the realm of the copyright owner, J.K. Rowling's interest. And then even something like a Andy Warhol adaptation of a photo, like this Prince photo down here, was recently held in a more controversial decision to be an unauthorized derivative work. So even though you have this pretty broad protection with copyright, there still are quite a few exceptions and limitations that come in to prevent the copyright owner from using sort of too much of what is of their underlying expression. So the main one that you probably heard about is that all copyrights will eventually expire and enter what's called the public domain. So this usually occurs 70 years after the death of the author, of the person who created the work. Interestingly, Mickey Mouse, which will enter the public domain in 2024, when Steamboat Willie, the first Mickey Mouse cartoon, reaches that period. It'll be interesting to see what happens when Mickey Mouse enters the public domain. You also can't copyright an idea. So if I'm a news reporter and I discover some new fact about the world, I can't copyright that fact. I can copyright, the way I write it down, the words I use, but I can't copyright just the idea of something happening. Functional works, things like, like the shape of a piece of clothing that has sort of some functional purpose, can't be protected. Work by non-humans can't be protected either. So this monkey photo over here it's called the monkey selfie case. This was taken by this monkey, and the court held that the person whose camera it was not the copyright owner, and that actually no one was the copyright owner because the author of the photo was a non-human. And then finally, and I think probably most importantly, we have the fair use defense, which comes in to excuse certain types of uses that might otherwise be infringing. it's a kind of complicated multi-factor test that is a little outside the scope of what of a sort of intro overview, but importantly, it can protect things like certain forms of new creation that borrow from existing creation. So, for example, we have this this photo from the Kynitz v. Scotty Nation case on the Seventh Circuit, where the court held that this sort of new use of a photo of the mayor of Madison, Wisconsin, was a fair use. There's other exceptions too that step in, if you, but these are sort of, I think, the main big ones. So this, of course, gets to the question of why we even have copyright to begin with. And the general understanding is that, it's important to allow creators to prevent other people from sort of appropriating their work in order to give them some kind of incentive to produce works to begin with. If they didn't have the ability to police their rights in their work, they wouldn't want to create those works anyway, because others would, free ride off of those creations. So we provide this kind of property-like interest in order to provide this financial incentive. But through the various limitations I just described, we still provide space for new creativity and public access. There are other theories as to why we have copyright. There's theories that talk about creative control and rewards for the labor that goes into creative works, but this sort of financial incentive theory is probably the predominant one that we see in the US. So that's copyright. Let me talk a little bit about trademark. So trademark is really quite different. Trademark is not about new creativity. It's not about inventions like patent. It's about brands and consumer confusion. So a trademark protects a word, a name, a symbol, or a logo. It can also protect product packaging or product appearance. That's often called trade dress, as long as a company is using those symbols commercially to distinguish their goods from another, or to indicate the source. So a trademark generally should be pretty distinctive. It can be, descriptive, but it's much easier to get protection for something fanciful or arbitrary like Lego or Google than it is to get protection for something like hotels.com, very, very descriptive. Trademark can't be functional. So if I can't trademark, the shape of a shirt, if that shape has some functional purpose to it. And a trademark only protects things that you're using in commerce. So you can't just trademark something and hold on to it. You actually have to be using the trademark to refer to specific goods or services in commerce. Like a copyright, you can register a trademark in order to to get this protection or sort of cement this protection, but you don't have to. You really only need to be using a word, a name, a symbol, a logo commercially to refer to your goods or services in order to get trademark protection. There are benefits to registering it, which you would do with the Patent and Trademark Office. You get better remedies in litigation and the like, but you don't need to. Although if you see this R sign, that's generally a sign that the trademark has been registered, versus the TM sign, which means the brand wants to show that they're using it as a trademark, but they haven't actually registered it. I want to talk a little bit more about the use in commerce requirement, because this is where we see a lot of interesting aspects of trademark law. So if you stop using a mark, you can actually lose it. It can kind of be abandoned. Someone else can start using it and you're out of luck. But if you keep using it, it basically won't ever expire, unlike a patent or a copyright. But if you let others use it too much without granting them permission, there's also a risk that you'll use it, because there's a risk that the mark will become what's called generic. So you'll see things like Velcro recently launched a campaign trying to get people to stop using Velcro to just refer to any adhesive system, basically by trying to get people to not turn this into sort of a generic term. Xerox also had a similar campaign. I think they probably kind of lost that campaign, and it's probably imminent that they're going to lose their trademark in Xerox, because it's just become synonymous with copying generally. So then what does a trademark give you? So the main thing it gives you is the right to prevent unauthorized use of a mark that's likely to cause confusion among consumers about the goods or the origin of those goods. So classic example, the 7-Eleven trademark logo. So the Super 7 someone started using the Super 7 logo and as a mark for a convenience store, and the court, I think in Texas, held that this was clearly infringing. Generally, likelihood of confusion is a sort of complicated thing to assess, but courts use a variety of multi-factor tests, some of which use things like consumer surveys and the like to try to determine whether there is truly confusion between two different competing trademarks. There's a separate cause of action that a trademark can give you as long as you have what's called a famous mark, and that is to prevent dilution of the mark. So this is a sort of strange area of law that basically says you can prevent uses that might ruin the power of your sort of famous brand, your famous trademark, often through things like using it derogatively, or through using it in areas where you haven't yet, in types of markets that you haven't yet entered. So a sort of funny example is this, the North Face sued the creation of the South Butt trademark, saying that this was a derogative use of their mark that was going to dilute their brand. The case eventually settled, so we don't quite know how it would have turned out. I will note that there's a parity defense to trademark dilution and trademark infringement, and that defense might have very well worked in this case, but we don't actually know what happened. So then, just like I talked about why we have copyright, there's a whole set of other reasons why we have trademark. The main ones are that it prevents consumer confusion about source and quality of goods, and it relatedly prevents a competitor from profiting off of the reputation of an existing brand. And the theory here is that this is, important for consumers generally, but it also incentivizes brands to, make good products because they know that they'll be able to hold on to the goodwill that those good products create, because other competitors aren't going to swoop in and trick consumers into thinking that they were the ones who created the product. So that is the sort of predominant theory of trademark law, although there are certainly other theories as well. So with that, I will end there and turn things over to Professor Safran.
Let me jump in here for a second. We have so many great questions, and while things are still fresh, if you don't mind, Jacob, I'm just going to throw two really quick ones at you. And I want to say, if you are a student and you've asked a question and we don't get to it, we're going to follow up with you. So Jacob, the two really quick questions. One is the perennial question: is Mickey Mouse is Disney gonna find a way to keep Mickey Mouse out of the public domain? And then another new forward-looking question is, do you have any quick opinion on how NFTs are going to change copyright?
Sure. So Mickey Mouse, it's interesting. The reason why we have 70-year term right now for copyright after the death of the creator is because Mickey Mouse was about to lose their copyright, and the Disney was about to lose their copyright, didn't like that, and managed to get the whole term extended for the entire system. So yes, the question is what's going to happen when this is about to expire. There's some theories that, the reason why we see those little mouse heads appearing so much in the Disney logo now is because Disney's going to try to use trademark law to police that Mickey Mouse symbol, basically saying that you cannot possibly ever use Mickey Mouse in a way that would, in any other way except to show that you're operating under the Disney brand, and doing so would actually infringe a trademark. There's a sort of weird copyright trademark hybrid effort, and it sort of remains to be seen what will happen. For NFTs, it's an interesting area of law. There's a lot of, sometimes we've seen this with a recent case where a bunch of what I think people call them crypto bros bought a screenplay to Jodorowsky's Dune adaptation, seemingly thinking that this would give them kind of a copyright in it, as well as the ability to make NFTs of it. Not realizing that copyright is its own area of law. Just because you own an NFT in something, you own the legal right to a specific maybe digital image, or to show, basically you own the legal right to say that you own an NFT in that legal image. That doesn't give you any of the rights that correspond to the copyright in that image, including the ability to police people from using it or copying it and the like. So maybe we might see copyright and NFT sort of hybridize, using NFTs and attaching copyrights to them, and then using the blockchain to keep track of ownership and the like. But right now, the two areas are pretty distinct, which has led to, I think, a lot of confusion among consumers.
you so much. Now, Professor Safran.
Okay, thank you, everyone. Let me share my screen for a second. Okay, so according to the most recent report by the U.S. Chamber of Commerce, in the United States alone, IP supports over $6 trillion in gross domestic product and more than 45 million jobs. Patent law plays a huge and foundational part of the constellation of IP rights. It is the branch of intellectual property that protects innovation, and the hero of patent law is the inventor. The biggest issue over the last 2 years has been the COVID pandemic, and one of the biggest triumphs over the last 2 years has been the unprecedented speed of the identification of the COVID genome and the unprecedented breakneck development of COVID vaccines. So over the next 15 minutes, I'm going to provide an overview of patent law, and to make things a little bit interesting, we will consider, to the extent we can, patent law through the lens of COVID innovations. Now, before we start, what is a patent? A patent is a legal right given to inventors to exclude others from making, using, or selling their invention. Patents are limited in term. They only last for 20 years from the time of filing a patent application. However, patents are very powerful in that, unlike copyrights and trademarks, they do protect the functionality of an invention and not simply its particular manifestation or expression. Patents, unlike copyrights and trademarks, are very expensive. They require a grant by the government. They don't exist unless the government gives you that, and that's true in the United States and every other place in the world. And the patent prosecution process is actually quite costly. So let's turn now to patent law in a nutshell. What must an inventor, our hero, do in order to get a patent? Two things. The inventor must have invented a patentable invention, and two, the inventor must disclose the invention in a patent instrument. So patents are the exact opposite of trade secrets. Trade secrets are all about, shh, don't tell anybody, and patents are all about, tell us, teach us your invention. So what makes an invention patentable? There are 4 requirements. 1, the invention must be patent eligible subject matter. 2, the invention must be new. 3, the invention must be non-obvious. And 4, the invention must be useful. Now, what do we mean by patent eligible subject matter? There are many discoveries that, even though incredible and the work of genius, cannot be patented. In the spring of 2020, in breakneck speed, scientists identified the genetic sequence for COVID-19. This identification held the key to nearly all future vaccines and therapeutics to combat COVID. Could the genetic sequence to COVID-19 be patented? No. Why? Because natural phenomena, scientific truths, and abstract ideas are ineligible for patent protection. Einstein could not have patented his theory of relativity. Newton could not patent the laws of physics. And the genetic sequence for COVID-19, valuable as it is, occurs in nature and belongs to the public domain. To get a patent, the thing sought to be patented must be man's handiwork and not nature's handiwork. Let's now turn to the second requirement, novelty. You don't need you don't need to come to patent law to know that in order to get a patent, the invention must be new. Things that are already out there simply cannot be patented. What makes something new for purposes of patent law is governed by Section 102 of the Patent Act and is the subject of over 2 centuries of complicated Supreme Court cases, which you can learn about when hopefully you take patent law. But let's take a peek at COVID treatments through the eyes of novelty. Data from the Pharmaceutical Research and Manufacturers Association of America, PhRMA, showed that at the end of 2020, almost 1,600 clinical trials were taking place globally to test treatments and potential vaccines for COVID-19. Of these, almost 2/3, 994 trials, were actually simply testing existing medicines to see if they might work against COVID. Can you patent an existing drug, such as chloroquine, to treat COVID? The answer to that is no. Why? Because these drugs already exist. They are not new. But what about your discovery that an existing drug can be used, can have a new use, namely, you can use it to treat COVID? In the United States, you can actually patent the new use of an existing drug. That patent, however, would be narrow. It would only cover the new use that you actually discovered and not the drug itself. In other countries, such as Israel, you cannot patent a new use of an existing drug. Thus, in the United States, if you were the first person to discover that chloroquine, or bleach for that matter, could be used to treat COVID, you could probably patent that particular use, but not the compound of chloroquine itself. Why? Because that compound, chloroquine, already exists, and your discovery of its new use is not a discovery of a new drug. So what about Pfizer, Moderna, and J&J vaccines to treat COVID? Can you patent those? Yes. These are new and can be patented. And in fact, there is a huge amount of litigation going on right now on who owns what with respect to these blockbuster vaccines. I mean, it was just reported last month in the Wall Street Journal that Pfizer and Moderna posted a combined $3 billion of revenue for COVID vaccines. Moderna is already paying $400 million in royalties to people who hold the patents, including the University of Pennsylvania, for inventions upon which these vaccines were made. Now let's turn to non-obviousness. Let me go back for a minute. What does it mean for an invention to be non-obvious? So even though your invention may be new and that it's not technically out there, you cannot patent it if it is obvious in light of what is out there. So if I was the first person to invent a blue marker, I could not patent that blue marker, even though it's new, because it is obvious in light of the fact that, you know, we have markers of many colors out there. And in fact, we have blue and non-marker writing instruments. So it is obvious that you could take this blue ink and plunk it into these markers, and voila, you have a blue marker. So you could not patent that. What about, now let's think about this, what it means for COVID. Well, there are numerous tests out there, we've all taken them, for which patents have undoubtedly been sought. Depending on how similar these tests are to tests that are already out there, they could run into trouble from a non-obviousness standpoint. We have also seen a barrage of different masks that we're donning to prevent the transmission of COVID, To the extent that some of these masks are new, and some of them probably are new, in most cases, they would not be able to get patent protection because they would likely run into non-obviousness problems. Now let's turn to our final requirement, that the invention must be useful. What does it mean that you cannot patent a useless invention? What does it mean for an invention to be useful? I explained this in my patent law class that says, what if we took a cup and passed it around the room or a virtual room, and everyone was invited to throw something in the cup. Someone here, I'm going to pour in a little bit of coffee. Someone else could drop in a little bit of ink. Everyone could put something in this cup, and at the end, we would swirl it around, and voila, we would have a new goo, a disgusting goo, so to speak. But we don't know what that goo does. So we couldn't patent that goo, even though the goo was technically new and not obvious. What this means in the real world is that pharmaceutical companies can't just generate a bunch of compounds and get patents on these compounds. They have to know what these compounds actually do. Now, it is not enough for our hero, our inventor, to have invented something glorious, something new, non-obvious, and useful. Our inventor must actually tell us, teach us what they have. That is called the grand bargain of the patent system. In order for inventing something new, non-obvious, and useful, and disclosing it, teaching it to us, we, the country, will give you this very powerful legal right that we call a patent. So for Pfizer, Moderna, and J&J to get patents on their vaccines, their patent applications actually must teach the world how to make and use the vaccine. Why is this? Because the overall goal of the patent system is to expand the realm of human knowledge. Once the patent term is up, the invention bleeds into the public domain, expanding the storehouse of human knowledge. If an inventor wants to keep his invention a secret, they can use trade secret. If the inventor wants a patent, the inventor must disclose and teach the invention to the world. That's it. Patent law in 15 minutes.
That is a tour de force. Okay, so let me start with Sabrina with a question for you, but actually, Jacob, you can pipe in on this too. And this is a favorite for us professors who are writing exams, which is about the yoga routine or the exercise routine. So let me ask, I'll start with you, Sabrina. What would it take to patent, if you could imagine, a yoga routine? There actually are cases about copywriting yoga routines, so we'll come to that in a minute. But Sabrina, would it be possible to patent an exercise or specifically a yoga routine?
I think probably yes, that would be viewed as a process patent, a method patent. You would be describing a series of steps, First you put your left foot in, then you put your right foot in, then you turn yourself around, you do the hokey pokey, and there you've got, there you have it. That being said, while theoretically possible to get a patent, on a yoga routine, it could be very, very difficult to do so. One, you would have to show that it was not in use, not only in the United States, but anywhere in the world, so no one in India is practicing your particular yoga steps. Secondly, you would have to show that it's not obvious that what you've done, that a person skilled in yoga wouldn't be able, given all the yoga steps that are out there and all the ways of combining those yoga steps, that it wouldn't be obvious to a person skilled in yoga that after the downward dog, you could do the rising sun or what have you. So I actually think that while theoretically possible, I think it would be very, very difficult to do.
Jacob?
Yeah, so this is an interesting area of copyright, and there was actually a Ninth Circuit decision about Bikram yoga and whether it was copyrightable. And there were a variety of theories offered as to why it wasn't. The court ultimately accepted the theory that that Bikram, the poses in Bikram yoga are sort of an idea or process rather than expression, and therefore outside the scope of copyright, possibly within the scope of patent, although as Professor Safran pointed out, there's some barriers there as well. I think there are several other alternative theories about why yoga might not be copyrightable. One is originality. I mean, these are fairly ancient poses, so you would have to show that you actually, kind of came up with it. And then also fixation is an issue. Choreography and the like is copyrightable to the extent you can kind of describe the choreography, but it's much harder to copyright sort of visual physical acts rather versus things like written text or music and the like.
So, right. So one of the things that we do in teaching IP and studying IP is we start to see the overlapping rights and claims that sort of transcend these silos of IP disciplines. And so if we're thinking about Bikram yoga, actually, and Bikram is also a trademark. And when Bikram started having a lot of troubles, not limited to the uncopyrightability of the routines, people who taught Bikram yoga, there was also a trademark dispute, and then people started to call it hot yoga. So there are lots of interesting things to talk about with yoga. So another question, let me throw this to you, Professor Safran. It concerns COVID and the vaccines and sort of the various that you talked about, and both of you talked about the balance that IP is always trying to strike between incentives for innovation and over propertizing and therefore making subsequent innovation more difficult. How does that sort of balance, how are you seeing that sort of pan out or be challenged in the COVID context? And are we starting to see governments assert rights to COVID vaccines in order to speed their rollout?
Well, I mean, these vaccines are subject to a lot of patent rights, and the technologies on which they are built are subject to a lot of patent rights. That's why the Wall Street Journal is reporting on it, and that's why Moderna is paying already $400 million in royalties. That being said, the companies did say that they would sort of make their technology fairly accessible. There was some hesitation to enforce patent rights over the vaccines themselves during the public emergency. So unlike what happened with AIDS, when the AIDS therapeutics came out, there was a massive international furor over patent rights over AIDS therapeutics, which were extremely costly and inaccessible. South Africa took a real issue with honoring patent rights over AIDS vaccines. I don't think we've seen that so much with the COVID vaccines. And I think that's because the companies have contented themselves with producing the vaccines, making money that way, rather than running around asserting their IP rights. I do think that the patented technology, I do think they have their eye on future things, future innovations that will harness their inventions using mRNA technology. And I would expect they're going to be vehemently enforcing those patents.
Can I add something quickly? So, in some of my answers to the Q&A, I talked about some other areas of IP, like the right of publicity and the like. One area we didn't really talk about is trade secret law, which is a sort of its own weird area of IP that protects, your ability to sort of keep things secret when they may otherwise be patentable or not, but just prevent people from appropriating your sort of know-how and the like, which can include things like creating inventions and processes and et cetera, although it's generally a bit more expansive than the subject matter of patent law. But with the vaccines, we're seeing a lot of sort of combinations of protection, so that where the vaccine itself might be covered by a patent, but the method for administering it might be covered by trade secret law. So even just getting the rights to use the patent doesn't necessarily give, a developing country, for example, the ability to mass produce the vaccine because of this complicated combination of trade secret and patent. So that's another sort of barrier that we're seeing, I think, to spreading vaccines around the world, even when there is sort of a more permissive licensing approach by the pharmaceutical companies with respect to the patent.
I just want to jump in for a second to just build on what Professor Victor said about trade secret. The one thing about trade secret that is untrue with patents is you are allowed to legally reverse engineer trade secrets. So maybe it can cover things for a certain amount of time before people have the time to reverse engineer or figure it out or what have you. But as soon as they do, too bad. That trade secret is gone.
Yeah, and maybe that's not so bad because maybe it actually wasn't new or not obvious enough. So Jacob, let me just stay with you for a second and kind of, I'm trying to think of like rip from the headlines. We're all thinking a lot about Spotify. We may be thinking about Joe Rogan, but I think, all of our participants will have some feeling about streaming and the artist's perspective on that. And without opening up, the very complicated question of how music copyright works, do you have thoughts on kind of what we may be seeing coming down the pike as kind of either licensing, sort of compulsory licenses, which I know that you've written about, or other kinds of innovations or interventions into the marketplace for copyrighted musical works that can sort of more fairly compensate artists?
Sure. So, the issue with copyright, and I think IP generally, is, we have this sort of pretty broad public policy goal of incentivize, at least in this case of copyright and patent, to incentivize innovation. But we have these other goals about providing access and allowing follow-on creativity and the like. And the way we sort of, when we use IP to meet those goals, we're creating kind of a pretty broad brush form of property, and kind of hoping that if we calibrate the scope of that property, in the case of copyright, it expires after a long time. There's fair use limitations. In the case of patents, you have to register it, you have to provide the information about the patent, and it expires very quickly. We're still sort of hoping that the market's going to step in and allow for sort of the best calibration. So, we're going to, in the case of like a music copyright, we're hoping that by giving owners of music copyrights control over their work, they'll be able to negotiate with follow-on users and distributors like Spotify and record labels and get a fair amount of money, but still ensure that the public has good access to their work. And like many markets, there can be all sorts of reasons why this doesn't happen. They're called market failures. And in the case of music, there's quite a few reasons. So one, people often, I think, are mad at Spotify, feeling like musicians are mad at Spotify, feeling like they get sort of the short end of that deal, that Spotify gets to keep all of the proceeds. The musicians don't get that much. But what people don't really talk about is there's still a bunch of other stakeholders involved in those transactions. So the record labels are often actually the companies that own copyrights because of in music, because of the sort of ways in which it is required to work with a record label to enter into the music industry. So we end up with a situation where artists aren't getting that much, partly because record labels are still taking quite a lot, even though Spotify is taking quite a lot as well. So this sort of begs the question of, who's really to blame? Are we operating under sort of an old industry structure that privileges these kind of middlemen when they're no longer really necessary or as necessary? And is that what's causing these problems, or is it really about Spotify having sort of too much control over the market and too much ability to set rates and the like. I don't really know the answer to those questions, but there are a number of ways in the past in which the government's kind of stepped in to try to address these problems. So one, as Professor Goodman mentioned, is through actually regulating prices in the market through things called compulsory licenses. Fair use can kind of play a role there as well. So that, the problem with some of these approaches is it requires Congress to sort of get its act together and intervene, which is hard to do generally, and I think especially hard to do in copyright. But there are definitely solutions that could be used, regulatory solutions and the like, to try to sort of fix these markets and make them work a little bit better.
Thank you. Professor Safran, we have a question that I know is very close to your heart, given your background and your previous career at the State Department, which is a question about Indigenous peoples and Indigenous rights. And the question was formulated, I think we could also talk about copyright in that context, but how do Indigenous peoples kind of monetize or protect from monetization their traditional knowledge?
So in terms of patents, the actual knowledge itself is not patentable because it's out there, and it's been out there certainly for more than 20 years or whatever. I mean, it's not new. It's there. It's not new. It's traditional. It's been there for a long time. However, to the extent that it has not been shared outside of the community, so that it's internal knowledge that shamans know or what have you, that could be protected by trade secret to the extent that it was possible to keep it a secret. What can be monetized is things that build upon that traditional knowledge. So if people in the Amazon, for example, know of therapeutic properties of plants that they have lived with and used for a long time, they could form some kind of an alliance through contract law with a pharmaceutical company where they have a joint project with joint benefit sharing to commercialize or to figure out or a therapeutic that harnesses that knowledge. But the knowledge just by itself, given that it is traditional, it's hard to do. Trademark, like there was a discussion of having, for example, Blackfeet, I think it was called, soap. You could certainly trademark a certain Native American brand, for example, or a certain indigenous brand. And there is legislation in the United States, a special legislation that was passed actually decades ago, making it unlawful actually for non-indigenous people to claim that their pottery or something like that was Native American.
Thank you so much. I think we're going to close this out. I want to thank Jacob Victor and Sabrina Safran. I want to put in a plug both for the Rutgers Institute for Information Policy and Law, where we have programming and research around these issues of IP, but also more generally on tech and information policy and law. Also for the Rutgers Intellectual Property Law Students Association, and for all of our colleagues, including Mike Carrier, who's another one of our IP professors. We hope to see you on campus. Thanks so much.
Thanks, everyone.